First of all, welcome all friends that you join today's talk. And I am Thomas Chen. I am Dean of National阳明交通University School of Law. Today's topic is about the medical liability in terms of the application of artificial intelligence in medicine. This actually is not a new issue. I think since before 10 years ago, I made a study about the liability of surgical robot. Basically, it's about Da Vinci's liability, and at the time, there are already a lot of litigation in the United States, and some are in class action form. And actually, the liability, the amount of compensation, the remedy that requested is quite, million or actually more than $1 billion. So it's quite a lot of money involved. And also, we found that recently there's also a case in Taiwan. It's about Da Vinci surgical robot. Yeah, but for today's event, actually involve more about artificial intelligence, and this is particularly about algorithm. Issue that come from the defect of algorithm, and this area actually creates certain challenge to medical malpractice litigation, particularly on certain elements such as what is negligence, what is standard of care, and what is causation, and who can like an expert witness issue. Those are challenging. In terms of how plaintiff can successfully prove and how is fair to the defendant. And also, it might create certain unforeseeable effect to doctors' practice in the real world. So, but so far there is not many cases as we are aware. So we are happy to have today's guest that can give us about this topic. I have known Professor Vera Lúcia Raposo for several years, and I would say that she was one of the intelligent person and productive person actually I've ever met in the health law field. In the past, she made a certain study about, particularly in criminal medical liability and also reproductive technology issues. And recent year, she makes several actually more about advanced technologies like artificial intelligence and data privacy, and also such as facial recognition technology. Yeah, those are their recent accomplishments. Yeah, and she's now a professor at Coimbra University and Portugal. Yeah. So, and before that, she was teach at a faculty of law at Macau University for several years, and it's where I met her at the beginning. So we're happy that after she moved back to Europe, she had more opportunity to closely observe the development of those health law and AI law in the EU, and also can bring us so many advanced knowledge and insight. In the last year, she also gave us a talk in terms of telemedicine. Yeah, so we hope that in the future we will have more opportunity to invite her and share her insight with us. So let's welcome Professor Raposo. Yeah.
Well, thank you so much, Professor Chen. It's always a pleasure to be here. I would rather be there with you and to meet you in person, but of course, events right now are not very suitable to travel. Indeed, I spent several years in Asia. Actually, as you can see, I'm not in Asia anymore, but I brought a little bit of Asia with me. So I have all my things from my house in Macau. And well, as I told you, I'm looking forward to meet you in person. So as Professor Chen mentioned, I will be talking about medical liability in artificial intelligence. Let me, okay, let me, just give me 1 minute because, okay. Just give me 1 minute, please. Wow. Can you see my presentation now?
Yes, but it's not in full screen.
Yes, no. Now it is, right?
No, you need to share another screen with us. Another screen.
Wait. So, wait. I had the idea that this was all taken care, but for some reason, it's not. Just give me 1 minute. Okay. Let's see now. No.
Yeah, this is the right thing. I mean, just change your screen to, no, it's correct. You just need to.
What about this, Professor Chen, what about this one? Is this correct?
Yes, it is good, but it's not in the presentation mode. So you need to use the presentation mode.
Okay, my suggestion is that you share your whole screen first, then switch to the full screen phone of the PowerPoint.
Okay.
So now you shift to PowerPoint. Yeah, exactly.
Okay, there it is. Okay, we do this training. We always prepare it, but well, I'm not that used to work with this system. I usually use Zoom, and so sometimes there are accidents. I'm so sorry, but now you have the screen, right? You have the full screen.
Yes. No problem.
Thank you so much. So I'm also going to put my chronometer because sometimes I talk a lot. I have it prepared for more or less 45 minutes. I think it's okay. So we have some time to discuss between us. So as I refer, I'm going to talk about medical liability in the field of AI. And before starting with the actual issue of medical liability, just some very quick highlights about the possible uses of AI in healthcare for the ones that might not be so familiar with this topic. So listen, AI can be used in the most various scenarios. For instance, to triage patients. Right now, whenever we arrive to the hospital, there is a human person, usually it's a nurse, that does the preliminary assessment, namely to see how severe is our health condition. But this could actually be done with the help of AI. You can still have a human there in case it's necessary, but maybe to start the dialogue with the patient, but the interrelation between the answers could be done by AI, and ultimately, you could have AI posing the question, so no intervention of a human, just to see how severe is your health condition, and to assign, you know, a bracelet with a given color, like red, orange, green. So this is one of the uses of AI. Another one is, of course, to make diagnosis. AI, it's very well known for that, as a very high level of success in the diagnosis of certain conditions, certain types of cancer, for instance. Also, it can be used to predict future illnesses that the patient might have. And in this case, I want to highlight Deep Patient, which is a form of AI that has been very good analyzing the information that is in the electronic health record of the patient. And you know that a good electronic health record will have lots of information. And based on all these data, like, of course, your age, but also your blood sugar, your heartbeat, previous illnesses that you have, your family history, can predict which medical conditions you are likely to have in the future, and is doing that with a very high success in the predictability rate. And also, of course, to establish the treatment of patients. And here, like the champion is the IBM supercomputer Watson, that is very good in establishing therapeutic plans for patients. So, of course, there are many other uses. These are some of the possible uses of AI. Another very, let's say, promising use is robotic surgery. This is not new. We have it for a couple of years, but it's becoming more and more developed. Even yesterday, I was seeing a documentary about a robot that worked with 2 arms and could do very precise brain surgery. And they were explaining that one of the big advantages is that, well, we are humans, so our hand, no matter how trained and how skilled is the surgeon, our hand always trembles a little bit. And of course, in brain surgeries, you cannot have any trembling. So one of the added values of this kind of robotic surgery is that it can correct our natural trembling. So the bisturi actually is very precise. It goes on to the millimeter of that exact part of the brain in where the intervention is needed. And of course, it's much less invasive surgery. Instead of doing the huge cuts, let's say in the brain, for instance, you just have very small incisions, the level of precision, well, so many advantages. And another one is that it can be combined with at-distance medicine. Because this is a medical intervention. It's the Lindbergh intervention. Probably you heard about it. It has a couple of years now, where the doctor was in New York and the patient was in Strasbourg in France. So here you actually combine robotic surgery with AI, with telemedicine, because it's a form of at-distance medicine, also with cyber medicine, because you are using new information technologies to provide healthcare. So you see how all these concepts that nowadays are becoming so popular in healthcare delivery, AI, robotic, telemedicine, cyber medicine, they can all come together in one single situation, which of course is amazing, but needless to say, it raises so many legal issues that for us, it gives us a lot to think about. As Professor Chen mentioned, in the last months, I have been very focused in one particular modality of AI technology, which is facial recognition technology. Most of you probably are familiar with it, but in a different scenario. Like, for instance, in the airports, you use facial recognition technology. You have police forces using it to try to identify possible suspects of crimes. But actually, it is very useful in healthcare, and it's already being put in place. For instance, one of the things that facial recognition can do is to analyze our face features to detect if we suffer from some very rare genetic medical conditions. You have Cornelia-de-Lange syndrome, like in here, even some forms of Down syndrome, because some of these genetic diseases, they can actually have consequences in our facial features. They change a little bit the way our face looks. But sometimes that change in the features is so mild, it's so subtle that human eye cannot detect it. So it's very difficult for doctors to detect it, especially because we are talking about sometimes very rare genetic conditions. So it's not every day that the doctor has the opportunity to see it. With facial recognition, with the measurements that it does in the face, it can detect those genetic conditions and, of course, immediately start some kind of treatment when possible. Another added value of facial recognition, again, analyzing our facial features, it can analyze emotions. And once again, we are used to emotion analysis in a different scenario. Probably you saw these movies where the suspect is being questioned by the police and you have technology try to establish if the suspect is lying or not. Well, in this case, the analysis of emotions works in a different way because it can detect pain. Of course, you can ask me, but why do you need this technology? Just ask the patient if he's feeling any pain. Well, it's not that easy because we can say if you are feeling pain, but most of us have some difficulty in describing the level, the severity of pain. And moreover, remember that there are patients that cannot even communicate, like newborns or very young children. They cannot say when they are feeling pain, so you use facial recognition technology. People that for other reasons are incapable of communicating. Elderly patients, patients with some kind of mental illness, for them it's difficult to say when they are feeling pain and how severe is the pain, and that's why this technology becomes very useful. But facial recognition technology can also be used in the form of identification in healthcare, which probably is the one you are more familiar with. So you can use identification to do patient check-in, that is to prepare patient admission at the hospital. Because right now, when we go to the hospital, we can either go to talk with someone that is there and give our identification, and this person is going to say, please follow the corridor and go to room, whatever. In more technological hospitals, you can just pass your identity card in a machine and you will receive the instructions. But this will be like the next level, because whenever you enter the hospital, assuming that you are a patient that already has a record in that hospital, by using facial recognition, you are immediately identified. No need to talk with anyone, no need to show your identification. So you will receive a message in your phone or even in an app, giving you instructions to where to go and what to do. Also, this can be very useful before a surgical intervention. I mean, one will think that nowadays we don't have anymore those cases in which the wrong patient is surgically intervened. Like you cut the feet from the wrong patient, you take a kidney from the wrong patient. Well, actually, it still happens. We must understand that the hospital setting is very complex, and especially in ER, in emergency situations, especially when patients cannot communicate. Let's imagine the patient is already under anesthesia. It's very difficult to establish without any margin of error the patient's identity. You can use the patient identification, maybe a bracelet with a number, but still there are mistakes. Whereas with facial recognition technology, you can reach a level of success that is very high. And another form of facial recognition technology used for identification in healthcare systems is to control ins and outs from parts of the hospital that are not open to the general public. I mean, you don't want patients and their relatives going around the hospital and entering into restricted areas. Sometimes even not healthcare staff has access to all areas. So you could have like some kind of gate like that, a kind of gateway, and it will open the door using facial recognition technology. This is important, not only for the people going in, but also for the ones going out. You don't want elderly patients with Alzheimer or some kind of mental disease running out of the hospital. It already happened. It's very difficult sometimes to have someone taking care of those patients. You don't want children running away. You don't want babies being kidnapped. So with this kind of monitoring, with this kind of control, you could avoid some of these outcomes. So you see, it's also a very promising field. But how we come to the topic that will be the focus of my presentation, medical liability. And let me be very candid about it. The fact is that I'm not very sure about what I'm going to say. This is a very honest disclaimer. And the reason is this. We hardly have cases of medical liability involving AI in court. We don't, not even in the States where usually all these things happen, we hardly have. I mean, we have the simplest ones, but the complex ones, we don't. So courts have not clarified the issue. The law has not clarified the issue. You have our general norms on medical liability. They are silent on AI. In Europe, we now have this draft proposal on AI. I actually already gave a talk here about it, but it's totally silent about the issues as medical liability. You have many scholars writing papers, but there are many opinions. And right now, we scholars, the only thing we can say is we believe the solution will be that one. But we cannot guarantee for sure 100% certainty that if a given case goes to court, the decision will actually be that one. I cannot guarantee that. And I can assure you that no one can guarantee because we don't know. We don't know. We are still in the very beginning. These are the baby steps of studies on medical liability on AI. So based on this disclaimer, let me now start giving you my opinion, which, as I just referred, is an opinion. I cannot guarantee anyone that the outcome will be the one I'm going to share with you. So first of all, to highlight how the first difficulty when using AI in healthcare is doctor-patient relationship. Because in this case, you have a patient, you might have a doctor, a human doctor, but you have AI. And sometimes you, instead of having this triangle, patient, doctor, AI, you can only have patient and AI. So things become much more complicated. And one of the issues that we must discuss is empathy. Because as you know, empathy is the cornerstone in doctor-patient relationship, the relation of empathy, the relation of trust. And of course, well, machines, they are not empathic. No matter how developed AI is, no matter how intelligent AI is, empathy is still a weak point. Well, so based on these considerations, one might think, okay, doctors, human doctors won the battle. AI will never be able to operate as a doctor in a doctor-patient relationship. Well, I would say not so quickly. Because, look, first of all, nowadays, patients complain a lot about the lack of empathy from human doctors. You know that with all these new technologies, with the pressure of receiving a given number of patients per day, doctors do not have the time or even the mental availability to talk with their patients as they used to do in the old days. So sometimes the patient is talking with the doctor and telling all the things about his or her life, whereas the doctor is on the computer, more focused on the screen than on the patient, writing stuff. And well, I would say this is only natural because the doctor must input information in the electronic health record. There's so many patients the doctor must see. But of course, this comes with a price. There is a lack of trust and the levels of empathy are decreasing. In contrast, in what regards machines, we are now starting to have our first signs of what could be in the future machine empathy, so to say. For instance, I don't know if you have Alexa. I actually have one for just a couple of weeks, so I'm still learning how to talk with my Alexa. But here's the funny thing. If you have an Alexa, probably already explored something that is called the whisper mode. Here, what is that? Whenever it's activated, if you whisper to Alexa, Alexa will whisper you back. This is not empathy by all means. I'm not that naive. But these are the very first stage of machine empathy. And this can be very important. Of course, imagine you have children sleeping or even adults sleeping. It's important that you don't have an Alexa yelling. You want her to whisper like that and to talk in a very calm way. But now transpose this for the healthcare setting. You have patients that are nervous, that are afraid, even sometimes in panic, in a nervous breakdown. They just receive bad news. They have cancer or some other disease. To have a machine that can whisper back, this will be very important. And I think the next step will be that you don't even need to activate the whisper mode. You could have AI that immediately detects your emotions and your state of mind using eventually facial recognition, using analysis of the tones of voices and even the very words that the patient uses. And you know that you already have machines that do that, right? Speech analysis. So with this kind of technology, the machine will be able to detect if the patient is angry, if he's sad, if he's afraid, and to adapt the tone of voice and even the speech, the very words that the machine is using to the state of mind of that patient. And if that is the case, I think in the future, we could have robots to not only to provide healthcare, but even to provide all types of care. I'm actually now working in a project about something very interesting, geriatric robots. This is called geriotics. So robots that are care providers for people, for old people. This will be the future. And actually, this is already the present. But you can also have, if we continue to invest in some kind of empathic machines, whatever that is, you can even have end-of-life robots, end-of-life chatbots to give comfort to patients in the very last days of their life. So the issue of empathy, I believe, can be solved. Now, let's talk about liability and standard of care. Well, as you know, there is some differences between what is called the common law world and the civil law. But I think that in general, we can define, in a very general definition, the situation in which there is medical liability as the one in which there is an harm caused to the patient by a conduct that is both unlawful and culpable, unless, of course, you go for the non-fault system in which we don't require culpability. But let's go with the general liability. So a conduct that is unlawful and culpable from the healthcare provider. And here you can have a human doctor, you can have a nurse, of course. When I say a human doctor, I mean a human agent. You can have a legal person, such as the hospital, or you can have both answering in court. And there must be a nexus, a connection that we call causation between the harm and this unlawful and culpable conduct. So these are the situations in which you have medical liability. And one key issue here is that the doctor did not act as it will be expected from a reasonable doctor. Any reasonable doctor on that very same situation would act differently. So this is the standard of care established by the reasonable doctor that, when violated, together with all these other requirements, will lead to medical liability. So you have unlawfulness, culpability, harm, and causation. And especially in the common law world, it's very common to talk not in unlawfulness and culpability, as we do here in civil law, but to talk about the standard of care, the violation of the standard of care. So you can have different concepts, but they actually describe pretty much the same thing. There are some differences, but they are not very relevant here. So these are the requirements for medical liability. Well, so what about the standard of care in AI? Well, it becomes very blurred and very complex, because within AI, pretty much whatever you do can lead to some kind of malpractice. Look, even the very fact that the doctor decides not to use the AI can be considered a violation of the standard of care, thus leading to malpractice. Because the court can always say, look, doctor, you did not use the AI in this situation, and a reasonable doctor would have used it, would have used this new technology, so you have the liability. Or the fact that you use AI, all this new technology, but you actually do not have the technological expertise to use the technology. As you know, doctors in medical schools, they learn about medicine. They don't learn that much about technology. So especially if you are talking about doctors from an older generation, or that are not working in big central hospitals, very digital hospitals, chances are that those doctors will not be able to operate with this kind of so complex technology. So let's say that one of these doctors goes into the adventure and starts using AI without having the digital expertise. Maybe there will be some kind of injury for the patient for not being able to use the AI as it should have done. So here's the point. When using AI, there are so many forms of possible liability. There are so many reasons by which you can get sued that it's actually very complicated. I would say that from a legal perspective, the courts always have a very strong preference for consolidated medical care. Because you see, I think medicine, as any form of science, like engineers, people are much more adventurous. They like new technologies. They like to try, to experiment. Whereas for us in law, we tend to be very conservative. So in the case of medical liability, most courts tend to favor consolidated medical care instead of new, complex, digital medical care. So based on this assumption, I do believe that if, for instance, the AI system suggests that the doctor should follow a standard treatment, as I have here, I think the most secure way is to follow the AI recommendation. This will be the secure path for the doctor. First, because he is following the advice of AI, so he's following the technological path. But moreover, and I would say even especially, because the doctor is following a standard treatment, a consolidated medical treatment. So if the doctor does that, if the doctor follows the AI recommendation that suggests the doctor to do something that doctors have been done for ages, I think it's pretty safe that the doctor will not have any issue in court. However, the problem arises when the recommendation of AI contradicts the consolidated medical care. So for instance, when in a given situation, doctors are used to prescribe 5 milligrams of a drug, and in that particular case, AI recommends 8 milligrams of the drug, which is in contradiction with the standard medical proceeding. And in this case, I think the doctor is in a very complicated situation, because any of the options to follow what the AI suggests or not to follow and go with the traditional medical care, any of these two options can lead to some form of medical liability. If the doctor follows the suggestion of AI, the court can always say, this is too risky. You should have followed consolidated medical care. If the doctor does not follow AI recommendation and instead follows the traditional proceeding, the court can always say, why didn't you follow the AI recommendation? AI knows better. So you see, here, everything you do can put you in problems. However, I do believe that this complex situation is valid now, but in the near future, it won't be like that. And it's valid now, this situation, this imbroglio, this legal imbroglio, so to say, because right now, AI is still not part of the medical standard of care. Right now, to use AI is something really like a kind of digital adventure. It won't be like that in the future. I'm very sure that in the future, AI will become part of the medical standard of care. To follow the AI, it will be what will be expected from a reasonable doctor. Eventually, to follow AI recommendations and using AI, it will be even imposed by professional insurance policies. This is a prediction of mine. I might be wrong, but I do believe that this will be the future. And if that is the case, well, we will have a completely different legal scenario. I believe that in that AI future that is expecting medicine, the doctor will be protected from lawsuits and from medical liability by the simple fact that the doctor follows AI recommendation, no matter how unconventional that recommendation is. If the doctor follows AI, if the doctor uses AI, I think this will probably operate as a kind of liability shield. In contrast, if the doctor does not follow AI and goes with his guts, goes with his personal experience, probably then we'll be in trouble, because most likely the courts will tell the doctor, you should have followed AI. Even if the AI recommendation sounds very strange and, as I told you, unconventional, probably this will be what will get the doctor in problems, not to follow AI. Let me jump a little bit to a different question, still in the field of medical liability, but a very particular scenario, informed consent. So as you know, there are many cases right now of medical liability that simply resume to a lack of informed consent. Either there was no information or there is information but there was not proper consent. So informed consent is actually a very easy way to build a medical liability case against the doctor. Well, what are the issues here with AI? First of all, because AI is so new, I think that at the current moment, it will be difficult to define what is the reasonable information to be communicated to the patient. Because look, in all the other scenarios, we have many cases of the patient information being already dealt in court. So we know what is the kind of information that should be communicated to the patient. We don't have that set of cases involving AI. So in the very first stages of AI, I think it will be very difficult for courts to define with precision what kind of information should be communicated to a patient. The other problem, because look, just to come back to my previous scenario, this issue actually will be solvable in the future, because the more cases you have using AI in court, the more you will get a kind of case law defining the reasonable level of information to be transmitted to the patient. So as time goes by, this issue will be solved. This one, the black box problem, it's not that easy to be solved. So what is that? As you know, you have two types of AI, the white box, in which it's easy to understand how it works. Well, maybe not easy, but it's easier. It's not that difficult. Let's put it things that way. And then you have the black box AI, which right now it's the majority, in which the AI, it's so complex, so opaque, that no one really understands how the AI reach a given outcome. When I say no one, not even the engineers, the AI developers, people that created the AI. So if that happens, how can a patient communicate, how can a patient understand the kind of medical treatment that is going to be provided to that patient using black box AI? How can the doctor communicate that information to the patient if not even the doctor understands it? If not even the AI developer, the IT engineer, all these people, not even they understand it. So the black box AI, of course, raises some issues in what regards patients' informed consent. I also believe, however, that this issue can be solved, because in the end of the day, I don't think that the patient needs to know exactly how did AI reach a certain outcome, how did AI took a given decision. And the reason why the patient does not need to know that is because the patient will not understand. Most patients, me, probably many of you, we are lay people in what regards technology in AI. So even if we are explaining all these equations and algorithms, we don't get it. It's too technical for us. So I think what the doctor will be asked to communicate to the patient are the main risks of AI, the main weaknesses, what can go wrong. Only that. The doctor does not need to explain in detail how does the AI works. And here I do an analogy to what happens, let's say, in informed consent regarding a medicine. Whenever the doctor prescribes you a medicine, the doctor is not explaining the patient all the different details that happened during the clinical trial, the different molecules that were used for that medicine. It doesn't happen that way because the patient does not get it. It's too technical. So I think the same can be applicable to AI. The patient is only required to know the main limits and possible mistakes involving AI, the possible risks, not everything. And quite frankly, I even believe that the doctor is not obliged to tell the patient about AI in every given situation. I believe that there are a couple of scenarios in which the doctor has to tell the patient that he is using AI. But besides of that, there is not such an obligation. Just like the doctor is not obliged to tell patients about every single instrument that the doctor is going to use in a surgical intervention. It doesn't happen that way. So we cannot be more detailed with AI than we are in other kind of medical scenarios. So here I have the situations in which I believe the doctor will be obliged to tell the patient that AI is being used. And actually, let me tell you, this is not an idea of mine. I follow the conclusions of Professor Glenn Cohen, and because I find its conclusions in this particular are very relevant, and I totally agree with them. So those are the scenarios in which the doctor will be obliged, in my perspective, and in Professor Cohen's perspective, will be obliged to tell the patient that AI is involved. First, of course, if the patient directly asks. Suppose that the patient asks the doctor, "Doctor, are you using AI?" The doctor cannot lie. Of course, the doctor needs to ask, to tell the patient that AI is being used. Or when the doctor is using a form of AI that is especially opaque, is especially black box, it's especially confusing. I think in that case, this is a kind of risk that the patient is entitled to be aware of. Or when the use of AI is so predominant in that medical act that AI basically overcomes any kind of human intervention. I think in this case, it should also be communicated to the patient. Or, last but not least, when the use of AI is based in financial motivations and not in the patient's best interest. So if you use AI because you want to cut costs, not because AI is the best medical care, the patient should also be informed about it. Besides these particular scenarios, I don't think the patient needs to know that AI is involved. Now we come to the situation in which you need to allocate liabilities. I mean, who or what did cause the harm, and who or what will be held liable. And look, as you know, whenever you are talking about liability, no one did it. No one did it. In Portuguese language, we have a saying that says that liability dies alone. No one's to be with liability. No one did it. It was not me. It was not me. It was the nurse. It was not me. It was the doctor. It was not me. It was the hospital administration. It was not me. It was the medical device. Or it was not me. It was the AI. But the fact is that we will have cases going to court, and the judge will be asked to assign liability to someone, either a legal person or a human person. So how are we going to operate? And I think in this regard, it's crucial to do a distinction between complementary technology and replacement technology. So complementary technology is basically the common scenario that we have in healthcare. And this is not new, because right now we have very different scenarios, not related with AI at all, in which the doctor uses different forms of complementary technology. So the outcome, the legal outcome in court, I predict that will be pretty much the same that we have right now with other different technologies. We will have a kind of shared liability, shared between the doctor and the manufacturer of the technology. When things becomes more complicated is with replacement technology. Because in replacement technology, you have AI completely replacing the doctor. So the doctor or any kind of human healthcare provider will be there just as an spectator watching. The doctor will not have any kind of intervention. And in this case, I don't think it will be fair to hold the doctor liable. And so you can have liability from the manufacturer and eventually corporate liability from the hospital. I will deal with that in a minute. Let me give you a specific scenario so you can understand the difference between complementary and replacement technology. Let's talk about computerized medical prescriptions working with drug-to-drug interaction. So the doctor is prescribing using a kind of software that is an AI-based software that alerts the doctor for possible drug-to-drug interactions. There is negative outcomes that can happen in case two drugs are prescribed at the same time to the same patient. In the case of complementary technology, the doctor will receive an alert on the screen about the possible negative interaction. But in the end of the day, the decision to prescribe the two drugs or to prescribe only one lays with the doctor. The doctor is the one that decides. So this is a case of complementary technology. If the doctor decides to follow the recommendation from the software and not to prescribe the two drugs, and because of that, the patient suffers some kind of injury, then you have shared liability between the doctor and the manufacturer of that software. However, when it comes to replacement technology, the scenario will be different, because in this case, every single decision about the drug to be prescribed will be taken by the AI, by the software, and the doctor cannot change it. So if the AI decides that the two drugs cannot be prescribed together, it will not prescribe the two drugs, only one, and the doctor cannot change it. And if by chance the patient suffers some injury, well, I think the doctor cannot be held liable, only the manufacturer of that particular software, and eventually the hospital. I do believe, however, that there might be some specific scenarios in which it can go in a totally different way. And you can have medical liability even in replacement technology, in replacement AI. And that will happen when the decision to use replacement AI or not rests with the doctor. I mean, the doctor was free to decide if he was going to be substituted by AI or not. So let's suppose that the doctor decides to transfer all its power of decision to the AI. The AI takes the decision, that decision is wrong and ultimately leads to patient injury. In this case, I think that you can have liability from the manufacturer of the AI, but also from the doctor. So in court, what the judge will be called to decide is whether the doctor had reasonable grounds, or good reasons if you prefer, to transfer the power to decide to the AI. Let's suppose that you have an AI system that has been performing very good until that moment, but in that particular situation, for some reason, took a bad decision. Because the previous performance of the AI system was good, I don't think we can hold the doctor liable. I mean, any reasonable doctor most likely will transfer the power to decide to the AI. But let's now imagine the opposite scenario. Imagine an AI system that has been performing in a poorly manner until that moment, constantly making bad decisions. If still the doctor decides to transfer the power to decide entirely to the AI, I think the doctor can be held accountable, because no reasonable doctor in that particular case would have acted in that same way. I also suppose that the type of medical act in question and the risks associated with that medical act can condition the legal appraisal of medical liability. So for instance, if you are talking about minimal risks interventions, let's say to prescribe an aspirin, probably the court will be satisfied that the doctor simply follows the AI decision, and the doctor will not be required to do any kind of double assessment. But if we are talking about risky interventions, let's talk, for instance, about prescription of drugs to a pregnant lady that is always a risky patient. Probably in that case, the court will have to assess whether, besides the AI recommendation, the doctor did some kind of personal assessment. So the court will not be satisfied by the simple fact that the AI says, do that or do this. And if we come to counterintuitive interventions, I don't know, the only thing that comes to my mind now is to prescribe thalidomide to a pregnant woman. So some kind of medical decision that should never be taken, probably in that case, the doctor can never follow the AI recommendation, no matter how many double assessments there is. And in that case, the court will hold the doctor liable for following the AI decision in this kind of counterintuitive interventions. And there is no justification whatsoever for the doctor's conduct. I mentioned before corporate liability. There is the liability from the hospital. And I also think that there will be cases here of corporate liability. Of course, it all depends whether we are talking about a private or a public hospital. In some jurisdictions, such as mine, this is crucial to establish the requirements for corporate liability. It depends on the particular kind of legal bond between the healthcare provider and the hospital. So there are many variables here. But in general, I think we can say there are some scenarios in which the hospital is always liable: acquisition, maintenance, and staff training. So acquisition refers to the purchase of equipment, materials, drugs, medical devices, any kind of equipment, including software, AI technology. So if the hospital purchases a specific AI technology that has not a good reputation in the market, that is old-fashioned, and if that technology leads to some injury in the patient, the hospital will be held liable. Also, maintenance. One of the obligations of the hospital is to maintain all kinds of utensils, devices that it has there. In the case of software and AI, for instance, the hospital will be required to do frequent updates of the software. And if the hospital fails to do so, and because the software was not properly updated, if ends up making a bad decision that injures the patient, then again, the hospital will be held liable. And finally, staff training. Most staff will not be able to operate with AI. So these people will be required to be trained to acquire technological skills, technological proficiency. And this is the duty of the hospital. If the hospital does not provide to doctors, nurses, and everyone dealing with this new technology proper training, once again, corporate liability from the hospital. But what about manufacturer liability? Well, not most, I will say all jurisdictions have their specific norms on liability for defective products. But besides those norms, usually there are also specific norms with a very particular regime based on the need to protect consumers. Here in the EU, we have a directive that has a couple of years now. It's a directive from 1985, which is about liability for defective products. And this directive has a singularity. It established a regime of strict liability. So that means that the one that suffered an injury, the consumer, is not required to demonstrate in court culpability from the manufacturer. The only thing that is required is to demonstrate an injury and causation. And this, of course, it's very useful, very handy for consumers that suffer some injury. So what we need to establish is if this directive is applicable to AI. I mean, when it comes to hardware, no question. I am a little bit doubtful in what regards software. And my hesitation is based, well, it's based in many things, but the most recent event is this decision from the Court of Justice of the European Union, the Cron case. Well, in the decision, the court made a distinction between damages or harm, if you want, caused by products and services to clarify that the directive only applies to products. Okay, this is not new. Of course, AI is a product. My main issue is with the Attorney General opinion, because I don't know if you are aware of it, but in most decisions from the European Court of Justice, we have these opinions from the Attorney General, and these opinions tend to be very influential. Well, in this opinion, in this particular case, the Attorney General said that the directive only applies to the physical properties of products. And well, I don't think AI counts as a physical property in this case. So if this idea makes a trend, and if the court starts following this idea, I don't think the directive will be applicable to AI products. This, of course, will be merely transitory. This directive is actually in the process of being revised. It will become a regulation, and more important than that, it was already announced that it will include specific provisions regarding AI in order to embrace this digital future in which the EU is very interested. So most likely this new regulation on defective products will deal with AI in a very specific manner, and this regime of strict liability may also apply. At the present stage, with the directive, it's not certain. And the other issue when assessing how medical liability involving AI is that things will become even more complicated the more independent and autonomous the AI becomes. Because right now, we have not reached that stage. But I think in the near future, we can have some forms of AI that will be so autonomous, so independent, that no one, nor the IT developer, the engineers, people using AI, let's say the doctors, the nurses, the hospital, no one will be able to predict how AI will behave in a given situation. The outcome of AI will become a complete mystery. So this, of course, will jeopardize liability from all these other stakeholders, all these other natural and legal persons involved in the process. How can they be liable? How can we demonstrate in court their culpability? And more than that, the nexus of causation, if the outcome of AI will be so unpredictable. Well, the fact is that patients will suffer some kind of harm, they will require compensation, and it will be very difficult to establish liability from all these other stakeholders because of culpability and because of causation. Probably the only option is to hold AI in itself accountable, liability of AI. This, of course, will not solve every issue. Actually, it will just start an entire new bunch of issues. And this option right now, as things are, it's impossible because, as you know, AI has no legal personality. Right now, AI is just a thing. But what about in the future? Well, if we agree that AI should have legal personality, and there are many scholars advocating for that option, and even the EU, in some preliminary recommendations and guidelines, also kind of follow that path. If that is the case, if AI becomes a legal person, then it can become liable. Still, it's not the answer for our question, because even if AI is liable, the fact is that AI has no assets to pay the compensation. So how could we pay compensation to the patients? Most likely, we will have to establish a compensation fund in the name of AI to compensate these patients. And many issues that come from here, just thinking out loud, probably we also will need to contract some kind of insurance policy for AI. So as you see, this option, considering AI as a legal person in order to be held liable, is not the end of our problems. It just starts an entire new bunch of problems, and we will be asked to think about it. Now, I'm coming to the end of my presentation, and I think at this moment, the question that comes to our mind is AI better than humans? In the field of healthcare, of course. Can an AI doctor replace a human doctor? And I don't have a proper answer for that. The fact is that every day we receive so many news and information saying that AI is beating doctors, AI is better than doctors. So frankly, I don't know. I think that for the complete replacement, so we can have this replacement technology, which is quite frankly, the one that will create more issues in terms of liability, there are still some hurdles that we need to consider. First of all, the fact that people don't like robots. I was reading a study from the University of Boston, and they asked many people, listen, do you want free healthcare being provided for a robot? And most people said no, because it was a robot. Most people prefer to pay from healthcare as long as it is provided by a human person. I do think, however, that this is about to change. The more that technology and robots it will be part of our life, our perception will change, and in the near future, we'll be very used to robots. Another potential problem that we have to deal with is the lack of empathy. But as I already mentioned, this is also changing, not only because more and more doctors are revealing less empathy, but because machines are also starting to be, I don't know if you can call them empathic, probably it's not the correct word, but kind of empathish, let's call it like that. The other issue we have with AI to become that replacement technology is, of course, AI to be developed needs terabytes of data. We need data to feed AI, to train AI, to test AI. And of course, we have many issues with data, especially because we are talking about, in the healthcare field, we are talking about sensitive data, such as genetic data, health data. And especially here in the EU, we have the most stringent data protection law in the world, the General Data Protection Regulation. So this might create an obstacle to develop this replacement AI. However, I also think this issue is solvable because, first of all, you can use anonymized data instead of personal data, even though I'm not a big fan of this solution because, well, data are never really anonymous. And right now with reverse engineer, we always can come back to personal data. The other issue is that, or the other solution, if you want, is the European Health Data Space Regulation. I don't know if you hear about, but this is the new promise in the field of reuse of health data and sharing of health data here in the EU, also to combat the many limitations of the GDPR. And I think this will open many doors because one of the main targets of this European Health Data Space is precisely to encourage the development of AI technologies. And last but not least, synthetic data, which according to most experts are not a form of personal data and therefore are not regulated by the GDPR, by the General Data Protection Regulation. So probably using all these resources, we will be able to get the data to feed and create this more developed AI that will be the replacement technology. Then we have the issue of bias. As you know, there are many issues with the limitations with the AI, mostly because it has some bias regarding certain ethnic groups and certain genders. I also think this issue is solvable. It seems that the more developed AI is not that biased as in the previous times. So we are developed, we are getting better. And in the end, it's not the technology in itself that is biased. The bias comes from the data with which we feed the AI and the very bias of the human engineers that program the AI. So I also think we can solve this issue. The one thing we probably cannot solve is the last one, predictability. Because you see, AI is very predictable. In the end of the day, AI is a bunch of algorithms. So it works under the logic if then. It works well in scenarios that are simple scenarios where the if-then logic can operate. But in very complex scenarios, let's say very complex surgical interventions, I think AI can be very useful as a complementary technology, not as a replacement technology. Because in those complex scenarios, you need someone that can think out of the box. You need someone that can deal with the unpredictable. And of course, only humans can do that. So what about the future? What can I predict for the future? I don't know if we are kind of lost in litigation. There are many unpredictable factors here. There are many unknowns. I give you that. I know that this is a little bit blurred, especially for doctors that are now trying to use AI for the first time. But what I can tell you as a digital lawyer and as a health lawyer is that I think in the future, AI will play a huge role in our lives in healthcare delivery. If not as a replacement technology, I don't think this can happen in the near future and probably is not even desirable, at least as a very useful complementary technology. And I think, well, I'm eager about the future. I'm looking forward with the times that are coming, and I just want to share with you my enthusiasm. Thank you so much.
Okay. Yeah, thank you. Thank you for Professor Raposo's great, amazing talk. Yes. So we now have open. Now it's come to the Q&A stage. We have one question from Jieyu. Jieyu say that is there any chance that to solve this with the institution for AI injury compensation? Which involves the manufacturers, the hospital using AI, etc. And those who involve will need to pay to membership fees, which the amounts will be relating to the compensation that they were to be planned.
Well, I most certainly this could, if we indeed become AI liable, we will have to go for the compensation fund. Right now, I don't have any other option. And of course, this kind of membership fees could be a good option to subsidize the compensation funds. And quite frankly, probably this could be a solution even if we don't get AI liable. I mean, just there are many other situations within healthcare in which there are compensation funds. For instance, for situations in which we all agree it's very difficult to demonstrate the requisites of liability in court, and we go with the non-fault system, and these non-fault systems are paid with compensation funds that usually are subsidized with membership fees. So if we, to summarize, if we hold AI liable, right now I can only see that option. Even if we don't hold AI liable, this is, of course, always a possible option instead of operating with the regular forms of liability. Yes, I agree with you.
Okay, thank you. Is there any others want to ask questions? Okay, if no one want to ask, then I prepared several questions to ask. Yeah, first of all, actually, I have quite a lot of questions. I mean, anyone can interrupt me if you have other questions. First of all, most when the AI product have been, before the AI product can be applied into the in hospital, it should have been got either a clearance or approval decision from the FDA. So in your analysis, that sometimes maybe AI's decision might influence with doctor's decision. So it seems means that the FDA actually regulate or influence doctor's decision. So I can see that there's indirect influence from the FDA. Yeah.
Oh, Professor Shen, I'm very happy that you've gone into that path, because for time reasons, I did not have time to talk about what happens before the doctors using the AI. Look, as you know, in Europe, we don't have the FDA. So if you don't mind, do you mind I talk about European scenario? Because I'm more familiar with it. It's not that different from the FDA, but what we have right now is that all these forms of AI being used in healthcare, they are considered medical devices, and that's why they are being approved by the FDA in the States. In Europe, our FDA, so to say, it's called the European Medicines Agency. Even though the one characteristic of EMA, European Medicines Agency, is that it doesn't deal directly with medical devices, only with drugs. With medical devices, we have other entities which are called the notified organisms. So the notified organisms, which you have in every single member state, are the ones that approve all kinds of medical devices, except the ones that are very simple. Because you see, in the EU, you have different forms of medical devices separated by class. So the simplest one, class A, class 1, sorry, they don't need to be approved by notified bodies, but all the others need. So you have the approval from notified bodies, and which is approving right now these medical devices using AI. And of course, when the medical device already comes with the approval, the doctor has this sense of trust. I mean, it was approved, it was tested, it should be good. And that operates with AI devices, and I think it operates with any kind of other device. We tend to trust in those products because they were submitted to a very strict scrutiny. Now, to make things even more complicated, we have this new proposal on AI from the European Commission. And the proposal comes to impose a new kind of assessment. So we'll have, I don't know if it will be a double assessment or a single assessment. The proposal is not very clear on that. But besides of the assessment that is being done to all kinds of medical devices, we will have an assessment that is foreseen for the so-called high-risk AI. So this kind of AI that is going to be used in healthcare will be assessed under the medical device regulation, very strict assessment, and under the AI regulation, a very strict assessment. One would say, after this assessment so strict, I'm pretty sure these forms of AI will not cause any injury. Well, it's not that simple, as you know. Even with all these assessments, one thing is all to test it in laboratory, to analyze all the information. But in the real world, sometimes things happen, right? So even though the doctors, of course, will be pursued by this, by the conformity assessment, by the fact of this AI was previously approved, and therefore it should be safe, it should be good. I don't think doctors cannot relax. They cannot totally rely, because you know that it's different, the assessment of a product before reaching the market and the way the product actually performs in the real world, in real life with patients. That's the only thing I can say right now, because we still don't have the experience in the EU of having this double assessment.
Okay, thank you. Now there comes 3 more questions. First of all, Raposo asked that any suggestion to improve or revise the traditional causation theory in the use of replacement AI?
Let me tell you that all the theories that we have right now about replacement AI are exactly that, theories. Because as for now, we don't have really replacement AI. I mean, we don't have any situation, as far as I know, in current medical practice. I'm not talking about what's being tested in the lab, but in current medical practice, in which the AI totally substitute the doctor. Right now, the scenarios in which we have AI, the last word always belongs to the human healthcare provider. So these theories that the doctor cannot be held liable right now are just predictions from scholars. We have not tested that in court because we have no case. So I don't know how the court will react. But to be honest, I do believe that if we have a scenario in which we have purely in total replacement AI, and the decision to use the replacement AI does not belong to the doctor, I don't see how we can hold the doctor accountable. I mean, the doctor is just being there and a spectator. The only way, in my vision, to hold the doctor accountable is if by some reason we still can say that the decision to be replaced belongs to the doctor. And most likely that won't be the case. Most likely, even the decision to use AI instead of a human doctor will belong to the hospital in its guidelines and not to the doctor itself. But I don't know I don't know the person who posed the question. What do you think? Do you think that even in replacement AI, the doctor should be held accountable? Can people intervene, Professor Chen?
We have Paul, if you want to ask question directly by your, you can turn on your microphone.
This is Paul. Sorry for that. I think you're right. I don't see actually so far there is any typical or physical chance to have a replacement AI in the real market. But so I think the causation issue is quite theory, because we have typically some kind of approximated but-for theory for the replacement of AI. But whenever AI they do something, they still have to have a devices to treat the doctor, to treat the patient. So I have no idea about how to treatment that. So how to decide the causation. But in the other side, I think it's also worthy to think about when we use the complementary AI, the traditional causation theory still has some problem. Who should take the liability? When we think about there are so many interruptions, cutting factors between doctors, AI, and patient. So maybe this is something that we can discuss later. Thank you.
Thank you so much, Paul. But look, I totally agree with you. Actually, if you think about it, in healthcare and in medical practice, the issue of causation is always very problematic. Is it with AI or without AI? Because there are many possible causes for the outcome. You can have the human healthcare provider, and most likely you don't have it only one, you have a medical team. You can have all kinds of devices and drugs being involved in the healthcare. And sometimes you must also consider the underlying disease of the patient. Sometimes patients die or suffer an injury because of the disease itself, and there is nothing that we could do. So one issue of causation in healthcare delivery, even disregarding AI, it's that it's always a complex causation, right? Because there are always many possible causes to an injury. Of course, with AI, it becomes even more complicated, because especially with black box AI, we probably don't know for sure, or we cannot establish the causation, because we don't know how the AI works. We don't know how, or the level of contribution of the AI for that particular outcome. And that, of course, black AI is a big issue when dealing with causation, black box AI.
Yes, I think.
Right, thank you.
For course action, question I should add more comments is that causation in medical malpractice is different with traditional causation theory. I mean, in law, what I mean is that in medical malpractice field, the causation issue is already non-traditional. Yeah, and yeah, but in terms of that replacement technology, my understanding is that now have certain type of device that control maybe by AI, that it automatically inject certain, for example, for diabetes patients, maybe those kind of device can automatically inject insulin into patient body. So the whole process might be automatically executed and made control by AI. And so can we say this is kind of automatic, it's kind of replacement technology?
Professor Shen, well, I don't know. I also heard about those types of technology that can inject drugs on the patient without human intervention. I don't know in detail, so I cannot. I don't know exactly what the level of human information. The last studies I read assure that this kind of replacement technology does not exist yet. So okay. I don't know if they consider that, if they might not have took that in consideration, or even in that case, it is not considered an entire replacement technology because there is still a human there. Quite frankly, I don't know.
Okay. Now, now the second question, Chen, actually I don't know how to pronounce it. If AI only acts as assistance, but not key role under doctor's orders, like AI assistant, MRI or CT image or pathology, will there be a legal problem?
Well, it's the same legal problem of whenever the doctor uses any other kind of technology. Look, imagine even a simple device. Let's talk about any kind of surgical tool that the doctor uses in a surgical intervention. If the doctor is using the tool and the tool has some kind of malfunction, like it breaks or whatever, it doesn't need to be technological. We always have an issue of deciding how to assign liabilities, because it might be the case that it's only the doctor liability because the doctor used the device in a wrong way, and that's the reason why it broke. There might be a case in which it's only manufacturer liability because the doctor did everything he was supposed to do, but the device was a defective product, and that's the reason why it broke. There might be a case of conjoined liabilities. Both the doctor made a mistake while using the device, and the device was not had some kind of defect. This is, I think I don't know if I think it was about another question that someone was talking, that not case-by-case assessment, but this is a case-by-case assessment. It's up to the judge to decide from the possible candidates to be held liable, doctor, even hospital. Imagine that the device is defective, but the hospital bought those devices, which were extremely cheap. And of course, you should suspect they did not have all the approvals, all the labels, but the hospital brought those devices to save money. Even there can be hospital liability, corporate liability. So there are many candidates, many possible players. In the end, it's the court analyzing all facts with all kinds of experts, which will decide if we have a case of conjoined liabilities or one single liability. I explained that with a non-technological device, but the same is transposable to this kind of complementary technology using AI. We need to decide the court needs to decide in the particular case, what's the level of contribution and the level of culpability of the different stakeholders.
Okay, yes. Okay, then finally, there's a question from Tao Lin Zhang. Yeah, the question is that since according to professor, patients won't know their prescriptions were done with AI. So what if doctor make a wrong decision due to the defection of AI? Then doctor who has no idea about law may feel guilty and claim themselves as crime and take all of the responsibilities. Then the manufacturer will not only escape from the punitive damage, but also have no chance to fix the AI problem. So maybe it is necessary to add another exception about revealing the involvement of AI. And thank you for your answer.
Well, remember this. If we are talking about doctors that are integrated in the healthcare system, like the public healthcare system, or that are integrated in a big hospital, I mean, if you are not talking one single doctor working in his office, there will be a bunch of lawyers that will never leave the doctor alone and will not want the doctor or the institution to bear the liability. I don't know if we have here in the audience lawyers working with medical liability, but I worked, and as you all know, when there's a case of medical liability, it's pretty much a game. It's just pointing the finger to someone else, the manufacturer. We know how it works, right? So unless you are a single doctor working alone in your office and you don't have a bunch of a legal team behind you saying, say it was a manufacturer, say it was a manufacturer, well, that doctor probably will be in a very harsh situation. But all the other ones, no one will leave the doctor, just accept the guilt alone. This will not happen. But also remember this. For instance, with the EU, and I can only talk by the EU, I don't know how it's in Taiwan. If some of you can explain me later, I will really appreciate. Within the EU, because we are talking about medical devices, one of the things that happen with medical devices, and the same with drugs, is that whenever there is an injury in some way related to a medical device, you need to report. Like drugs, like kind of pharmacovigilance, we have the same with medical device. So if not the doctor, someone involved, it needs to do the report, because all these negative incidents are to be analyzed, and ultimately the medical device can be taken from the market. This happens with all medical devices, AI devices included. And the AI proposal will establish the very same system. So it's not only a matter of liability. I don't think the manufacturer actually will have great chance of leaving this situation smiling and happy, believing, well, I'm free from liabilities. Even because of this reporting, mandatory reporting of any incident, ultimately, the manufacturer will be investigated. There will be some kind of investigation. Of course, it might happen the case that the product is not defective, right? And if the product has no defect, even under strict liability, there will not be liability, because the strict liability only excludes responsibility or less. Let me explain like this. The strict liability only exempts the matter of culpability, but it still requires a defect of the product. So if the product was not defective, if this only happened because it had to happen because the doctor worked with that device in an improper manner, the manufacturer will not be held liable. But I'm talking a lot about this. Let me just summarize, because I think it's getting a little bit complicated. I don't think there will be many situations in which the manufacturer will say, ha, 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 I tricked them all. It won't happen. Either by issues of liability or reporting of adverse incidents, we will get to that manufacturer. Because, as you know, consumer protection is becoming a big issue, especially consumer protection in the digital age in all jurisdictions. So I don't think manufacturers have any kind of liability shield.
Yes, I would like to add one more comment. Yes, Taiwan has a similar rules that is called, medical device manufacturers need to report those events, and it's called post-market surveillance.
Exactly.
Yes. But when I studied Da Vinci surgical robots 10 years ago, there's a situation that the manufacturer of Da Vinci suddenly decide to report some cases that they forget to report after they get sued. Yeah.
Oh?
So in reality, whether manufacturer will really report those events is questionable. Yeah. Okay. I have although the time is almost out, but I have two questions. I think maybe it's very related. One is that in one of your slides, you mentioned that for complementary technology, the defect would be will trigger to share the liability, means that maybe the manufacturer and doctor both are liable. Yes, but my question is that for the device, for product, the rules is strict liability, but for doctor, the rules is negligence based. Yeah. So how to it's kind of different since the principle is different. So how to decide how to share the liability?
Well, just one note, when I said share liability, and I think this actually became clear in one of my answers now, I mean that both of them can become liable. If in the end they are both liable, it all depends on the assessment of the courts, right? Just to say that both of them theory can be liable. But yes, as Professor Chen just said, they are under very different rules. One is strict, another one is regular liability based on culpability. So once again, this is a complex issue, but it's not new in the sense of AI, because we have that a lot, like with the drugs, with any kind of device used in a surgical intervention. It's not new, we already have it. And what the court must assess in those cases in which you have more than one liability is the percentage of causation, how much any of those players contributed to the final outcome. So it's not, at least the cases that I know, it's not that much that one is strict liability and the other is based on negligence that establishes the division of liabilities. This only conditions the requirements for each one of them to be held liable. What establishes if, let's say, the manufacturer will pay 80% of the compensation granted and the doctor 20%, is how much each one of them contributed to the final outcome. So it's more a matter of causation. At least here in Europe is like this. I don't know how it, maybe in Taiwan might be different.
Oh, yeah. This depends on countries' civil rules. Yeah. One more question is about staff training. In hospital liability, you mentioned that hospital might be liable for a lack of staff training. What I observed in the United States is that some plaintiffs sue the manufacturers for not enough training to doctors because salesmen, medical device salesmen, because they are eager to get profit and yeah, so they might sell to the doctor without full explanation, and also maybe not enough time to give doctors enough training. So, but in reality, it's quite common in the medical device industry that sometimes because surgical the surgery system, they might not get familiar with those new innovative device. So in reality, salesmen sometimes have to operate on the patient during the surgery because doctor might not familiar with the device. So so I'm wondering what's the situation in the Europe. I mean, is in terms of training, staff training. I mean, training a doctor. Is this the duty for manufacturers or the duty to hospital?
Well, actually, it depends. This kind of issues usually is taken care on the purchase contract. I remember that when I was working in the law office, I participated in the drafting of one of those purchase contracts. It was also for the device. So usually when the hospital purchases to the manufacturer any kind of, let's say, these devices, usually in the contract, there are some clauses establishing how, in case the training is necessary, and for this kind of devices usually is. So usually we tend to establish in the contract who is going to provide the training, who is paying for it, who is invite the doctors, like all kinds of issues, even the smallest one, even locations and all that. This is usually established in the purchasing contracts. And I strongly advise anyone involved in that to clearly identify in the contract. So to be clear, if it was the hospital that should have taken care of finding people to train the staff, or if it was the manufacturer, I don't know, all these big manufacturers of complex medical devices that is in charge of doing that. I never participate in a case, and quite frankly, I never found a court decision about a lack of training and trying to decide who is going to be held liable. I never found any decision, not saying that doesn't exist. I never found one. I would say in theory, if there is not in the contract, ultimately there are two kind of obligations here. The manufacturer should provide all necessary information for people that are using the device being able to use the device. Even because if that information is not provided, the product is considered defective. One of the factors that can lead to the defect of a product is the defect of information, according with our directive. But the final training, the responsibility to train the staff, this I would say belongs to the hospital. And that's why I strongly advise all hospitals that purchase this kind of very complex softwares to arrange beforehand in the purchasing contract clauses that assure that the manufacturer will help them or even take care of that training altogether. That's what I can say. That's what I will do if I was working for an hospital, as I was.
Yes, one more question. That is that the definition of replacement technology is complicated. In the UK, the case of Babylon AI doctor triage services, there is a debate as to when a doctor opinion is considered necessary. What happens when AME admits AI to told a patient with heart attack that his symptom is insect bite, has no need to use A&D pathway? Is that a diagnosis or administration decision? This Babylon AI doctor triage service is was adopted during the pandemic. It's a digital service that decide whether a patient can go to emergency room. It gives patient some instruction and maybe yeah. So and it's automatic and run by AI. So it's, maybe it considered as a replacement technology. Yeah.
Well, I don't know if I get the question very well because the question was quite long and sometimes I got a little bit lost in the details. I got the part in which it was being asked if it is a medical decision or administrative decision, right? There was a question, there was a part in which it was being asked if the decision from Babylon AI was a medical decision or an administrative decision, right? I'm talking to the person that made the question. Am I correct? Is that it?
Hello.
Hi. Hello.
Hi. Sorry, I can't quite hear myself.
I can hear you. I can hear you.
Yes. Yes, I think the situation here in the UK was because the pressure over the pandemic. So the hospital has adopted a system provided by Babylon, which kind of automatically triage patients. But to what extent that triage, because triage is usually in a traditional scenario, is actually done by a big team of medical professionals. You started probably by the hospital reception staff, which we would define it as admin, but then you probably have a nurse to do the first level of triage. But because due to pandemic and the stress of lack of staff, so we introduced a system that AI does probably part of the reception, part of the nurses, part of the doctor. So it's very confusing in what situation, cases we would say to what extent it has to replace the doctor. So there's a big row that there's a doctor actually tests the AI and then say in many cases a doctor would consider this is a very serious case, but the AI system actually give really we would say a really the typical negligent diagnosis and advise the patient actually just stay at home self-care.
Yes, no, I know a little bit about Babylon. We don't have it. I never went in an hospital in which you have it, but I heard about it. But as you say, Serene, this usually are things that are being performed, are actions that are being performed by doctors and nurses, and actually is a kind of triage. So there is still, now I opened the chat and I see that there is a part in which you actually ask if it is a diagnosis or an administrative decision. I think it's a medical decision. It's a medical decision about the decisions about triage are medical decisions as far as I see. Now, if it is a replacement technology, well, I cannot guarantee for sure because I never studied that particular technology in general. My question is there any chance that the doctor, there is a human supervision in which the doctor or the nurse can change the decision taken by the AI and so, no, this is an error, so I will decide differently? Can that happen?
I think the problem is because short of staff, the UK policy is actually using the digital triage to kind of replace a lot of these the need for medical staff. So it is in a way in many situations we already just put a system with all the potential diagnosis as a dictionary, like a dictionary, online dictionary for patients to help themselves to figure out whether I need to go to A&E or whether I can just self-care or go to pharmacy. So it's quite, I think it's a quite tricky question in it link between the, the more like the policy, the regulation and liability. Where did you draw the line? If the policy is we are going to give patient more power in terms of pathway, they choose whether they want to go to hospital, or I don't know how to. I just mention this because in my observation, I think it is going to be quite tricky in this situation if we allow like pharmacists and nurses more power to decide which pathway the patient should go for. So
yeah, but Serene, who does the final decision if the patient goes to the hospital or stays at home? Is the patient based on guidelines provided by the system? Is the AI system or is a human operator? that ultimately can reverse the decision of the AI system?
We actually have a quite big
well, Babylon is
yeah, I think there's a couple.
Babylon is a private company, so it's a service that is kind of created by them. So and the service actually trained by AI. I do not even use it, but it's different with it's not operated by person. Yeah.
Yeah, but what I was asking is because with the explanation of Shirin, I got just a little bit confused about who makes the final decision on whether the patient should look for medical care in the hospital or not. Because at some point, Shirin was explaining that there is all this information provided to the patient and a kind of patient empowerment. So is the patient that does check the criteria and say, oh, I don't go? Or is a decision from the AI, like the patient must answer some questions, tick some boxes, and then the AI say, you should go or she should go? Or ultimately, is there a human healthcare provider that is on the backstage, so to say, and does a filter of the decisions of AI and says, okay, this decision was bad, patient, you should come? How does it work in real life?
I think the problem is advice to the patient, but in certain situation you don't get appointment because you don't get the priority for the appointment, and therefore when there's short of space for appointment, you probably won't get appointment at all, even if you don't want to follow the AI's suggestion and you insist you need to have an appointment with the doctor, you don't get a priority.
Mm-hmm. Yeah, because if the patient suffers an injury because he or she did not look for medical care, whereas he should have looked for, in the case goes to court, what the judge will ask is who took the final decision on whether the patient should go or not, right? So that's the question I'm asking.
Yes.
Who? The patient, the machine, or a human?
Okay, if it is allowed, yeah, I have some comments. In terms of, okay, first of all, in terms of the salesman I just mentioned, actually, why I learned about it is because one of my students, when he wrote his master thesis, he planned to do a survey to patient. He's a surgeon, and in the survey question, the topic of studies about ghost surgery. Ghost surgeon means that the surgeon who will do surgery for you, but it's not the person who really do the surgery for you. Yeah. So sometimes the doctor's student, like intern, or their assistant, or another doctor in the hospital. Yeah. So, but on the survey, he has a question: who you are willing, who you accept that if it's not this doctor, and who you are willing to accept that if it's actually operated by him or her. So I see the option that including salesman. I was shocked at why salesman would do will be a ghost surgery. So, and he says sometimes it happens. Yeah. So I suggest that not put this question on the survey, because it seems that this study will prove that these kinds of phenomena really exist. Yeah. So so actually I don't know how often it happened, but it's what he said to me. Okay. And finally, I watch for Taiwan situation. Taiwan has first of all, Taiwan's Consumer Protection Act covers both product and service. So so if it's not a product but a service, is still within the scope of strict liability. But however, during the debate, a war between legal scholars about 20 years ago, finally the rule, the law changed, so it's include medical malpractice. So medical malpractice is not considered no fault strict liability, but from manufacturer side, whether it's a product or a service, they are both liable. Yeah. And another thing is that Taiwan has no fault compensation system for drug injury, and it's called 药害救济法. It's basically learned, adopt from German model. But the thing is that currently it does not cover medical device. So medical device is still excluded. But it is possible if we decide that to expand the scope of this no-fault compensation system, it is possible that we include those innovative medical devices into this system. Okay, so it's as time is a little late. So is anyone want to ask question? Any more question? So if there's no more question, then let's give a big hand to Professor Raposo for thankful for her speech today, and they give us so much insight and knowledge about in this field.
Thank you so much. I really appreciate you are here with me and explaining all these things about Taiwan and sharing, even without the particular case of Taiwan, sharing your ideas with me. I really appreciate.
Yeah, thank you. On June 9th, on June 9th, the next Thursday, next week, 下礼拜四6月9号, we have another workshop on social robots. From 9:30 a.m. to noon. So if you are interested, please go to our website and register for this event. Yeah, thank you for your participation tonight. Good night and see you next time.
Thank you. Bye-bye.
Bye-bye.